Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Be seated.
Good afternoon. We just have one case on the election calendar today, Mark versus Shen. I'll give you 7 and 1 and 7 and 1 in terms of the time, and then if we need more, we'll ask more questions, okay? So why don't you go ahead?
Thank you. May it please the court. Good morning, Your Honors. Anthony Genovese on behalf of petitioner, aggrieved candidates.
Do you want to use the...
Susan Liebman, here on an appeal of a dismissal order of the aggrieved candidate's petition. The motion sought dismissal based on the failure of the aggrieved candidate to file and serve specifications of objections at the Board of Elections pursuant to 6-154. There is no such requirement that the aggrieved candidate file such specifications of...
There is one, I'm sorry, but there is one with respect to an objector.
Correct.
So you don't dispute that you didn't meet the notice requirements as an objector under the objector regulation? Notwithstanding that the best practice is based on your secondary source in your brief, Mr. Goldfeder's book or treatise, that you do both, objector and aggrieved candidate petition at the same time to see where you could win.
That issue was not pursued, and it was not pursued because I had an aggrieved candidate proceeding. We served it two ways.
You're conceding that you don't have a citizen objector.
Correct. We're pursuing just the
position at this
aggrieved
time.
candidate.
Then why don't you focus on the issue of adequate notice? How possibly the short notice that was provided here could constitute adequate notice?
Okay. So the notice provided by an aggrieved candidate is devised by the court. Pursuant to 16116, the election law gives to the court the prerogative to determine notice. And what that section says is that verified petitions pursuant to Article 16 shall be brought upon such notice to such officers, persons, or committees as the court or justice shall direct. And the court here did just that. It, as every court in election law matters does.
We're talking about, aren't we talking about the time factor here, whether enough time was provided in respect to the objections?
I don't know what that is a reference to. Typically, the adequate notice concept is considered on commencement issues, on service issues. Here, and there are some cases, two of which the lower court cited, Alfieri and Lancaster, addressed adequate notice in the context of an aggrieved candidate filing specifications of objections. Those cases, and almost every case, I haven't found any case that said otherwise, considered the question of adequate notice.
The concept of adequate notice, whether that the party whose signatures are being challenged has enough time to adequately respond in advance of the hearing. So
Correct.
why don't we address that issue, whether or not this candidate had enough time under the notice provided here to adequately have a real opportunity to respond to the objection?
Okay, well,
And were you relying to some extent on the judge's own court rules that said when things had to be filed?
absolutely I was, because that's what 16116 provides, as does every court.
So each judge that's assigned the election part in whatever court sets out dates that things have to be done.
And specifically has two paragraphs all cited in my brief that identifies what aggrieved candidates must do in order to comply with the court's rules, which was exactly done here.
I just want to follow up, if I may, because the bill of particulars was served the morning before, about maybe 2 in the morning.
Correct.
Right? And that was the de novo review, but then also challenging the more than 10,000 signatures as well, right?
It was a de novo review, yes.
So, how could there be enough notice when the next morning it's 10 a.m. and there's going to be a line by line for all of those signatures?
Well, it wasn't the next note. It was the Wednesday is when the line by line started.
Uh-huh.
And remember, there is not only was this not a basis for the motion, the court. I don't know what the court relied on to determine there was not adequate notice.
That was going to be my question for you. What was wrong with the court's determination that there was not adequate notice in this case? What was incorrect about it?
Number one, it was sua sponte. It was not a briefed issue. I didn't know notice that the court was considering dismissing the aggrieved candidate petition on the failure of adequate notice for precisely complying with the court's rules. What is any practitioner or any aggrieved candidate to do? When they bring an aggrieved candidate proceeding and they comply with the court's precise rules on exactly when specifications of objections by aggrieved candidates asserting de novo objections must file them. We did exactly what the court said, but there is no...
Apart from the court rules, isn't there a legal requirement as to adequate notice? And isn't that always going to be part of the court's review when there's a petitioner aggrieved candidate?
There is, as I said, this concept of adequate notice, but again, typically what the concept considers is, does the responding candidate have adequate notice to defend the allegations?
Right, so that's the question.
So, correct, but particularly that typical allegation is a fraud allegation where respondent would have to get a forensics expert to maybe examine the signature or get witnesses.
But if
This is just a line by line. It's
right, but
out of
if there's
district.
no time for them to review what the objections are, doesn't that go to adequate notice?
No, I submit it does not. Here's why. Here, in the same sua sponte order dismissing on this argued ground of adequate notice, what the court said was, not only is there not adequate notice, but after 720 signatures reviewed, the courts determined that the responding candidate has such a successful rate of defending against these objections that we shouldn't even complete the analysis because they're doing so well. If this continues, you won't succeed. And my point is, it sounds like they had plenty of notice. All these are, this is not where you're going somewhere. This is you're sitting at a line by.
Let's say we put aside the adequate notice. What about the merits, which the court also reached? Why wouldn't the merits in this case justify the same result in terms of
the merits being the success rate of the.
Right.
Because to say that a court can guesstimate whether you will be successful. This wasn't a situation where we had 1,000 signatures left and we had to get 800 to prevail. This wasn't that at all. This was a situation where the board ruled that day, reduced the responding candidate signatures to 5,850, and 4,000 of what the board reviewed, 4,000 signatures, they didn't even consider whether it matched or didn't match, and there were de novo objections as to all of those. So this is not a situation where they couldn't review it, they didn't review it. We sat at the line by line, and the contention is, this is out of district. No, it's not. It's not a situation where adequate notice considers whether a special proof or a special witness or a special expert has to be retained to address these.
Thank you. Thank you. Yeah,
Okay.
time on report.
Thank you, Your Honor.
Good afternoon, Justices. Edward Hartzog for the respondent candidate, Janice Chen. If it pleases the court. Justices, I'll get right.
I'd like to,
What about the argument that wasn't even, that was a sua sponte position by the court about the adequate notice, and that wasn't even argued by the party?
I'm glad you asked that, Presiding Justice Kern. Notice, in our opinion, is endemic to due process. How could it not be? When we arrived on the 21st of April in court, we had yet to receive even the underlying specifications from appellant. We hadn't gotten those. As you see from the motion, they hadn't been served. Facially, it was defective all around. It was a promise that the aggrieved candidate would serve specs, as they are referred to, and we received those at 2 o'clock in the morning. I was asleep, but the next morning,
on which day?
the next day, the 22nd, we arrived per the part rules
But
of Judge.
wasn't that consistent with his part rules?
Yes, it was, Justice.
So how, if it was consistent, excuse me, if it was consistent with his part rules, how could it be a violation?
Well, Justice, the reason why it's a violation is that we did not have an opportunity to review them. And if we'd had an opportunity to review them, as I was going to prepare a more detailed statistical analysis for you today as to why mathematically it was an impossibility, what I discovered.
What I'm still troubled by is if a party complies with the court's rules with regard to notice, how can that be a deficiency as to notice?
Well, I think it was struck upon while appellant counsel was here at the podium. The fact of the matter is if we'd had more than a nanosecond with that volume of petitions to review the sheets, what we would have discovered is what we have discovered, is that facially both the specs and the underlying de novo specifications facially are defective.
That doesn't answer my question.
Well,
Excuse me. My question was, his rules require that you submit the bill of particulars by 10 a.m. on Tuesday, April 22nd. They submitted the bill of particulars at 2 a.m. on April 22nd, and the court found that that didn't give them adequate notice. Do you have any case law that says that where a party agrees with the notice required by the judge's part rules, that can be inadequate notice?
well, as I was getting to, Justice Gessmer, what I was trying to say is, indeed, the facts of the case bear it out, because if we'd had adequate time, I would have discovered the fact that if you will refer to NICEF document number 28, according to the specifications, page number 667, referring to the underlying spec 783, what happened is that the appellants double counted. The pages are off. The clerk's report reads 1110. Appellant specifications, underlying specs, end at page 1099. The real number is 1103. The reason why no one could discern that is because of the volume dumped on everyone like a document dump at the White House on a Friday afternoon. We couldn't get through it in time. It was only after days of review did we find that not only were the specs manipulated so that we couldn't find it, because on page 1099, what happened originally is that appellants misnumbered. They got to page 1019 and realized, oops, we goofed. So they put 1019-1, but you won't find that in the new de novo specs. Where you'll find page 1099 is on page 994, and the numbers end up at 1110.
I mean, we all know that the election process is very truncated. I mean, it's a very, very tight time situation from when the Board of Election meets and the court situation. But I mean, just to sort of emphasize Justice Gesmer's question, is Judge Perlman said, I'm the election judge, and these are the rules I'm setting out. This is when this has to be done, and then I'll have a hearing this time. If they complied, and I'm not disputing the fact that it was a very, very short time, but if they complied with the time that the judge said, how can they have anticipated that you would have said, oh, we didn't have enough time? They did it within the time. It was just a huge amount. I get it. I mean, I get it, but it was within the time framework that the judge had indicated he wanted the papers filed.
Well, that would be fine, Justice Kaepernick, that's great. But the problem is that the papers were on their face defective. And the election law, as justices are well aware, is extremely tight and is very unforgiving. Many phrase fatal defect, I think it's the only area of law that we practice in New York where fatal defect is so frequently sprinkled throughout the statute. And these specs, these de novos, are facially defective. And the fact that we got it so late prevented us, under due process, both substantively and procedurally, from raising the issue with Judge Perlman while we were in front of him. We could have raised that issue, pointed to exactly as I have for the record here. When you look at NICEF document number 28, you will notice I will not speculate as to motivation, but I will suggest respectfully to the court that it was not negligence nor recklessness that resulted in this numbering, and I would strongly, respectfully urge the justices to review the documentation to see what was going on. We were unable to get there. In addition to which, respondent just basically says to the justices respectfully, we agree wholeheartedly with the decision. Do notice Notice was argued from the beginning. It is our contention. Due process, notice, it's endemic, it's axiomatic. It's like being told to breathe. Notice is part of due process, and we are in administrative law and the administration
You're
of
saying that,
election
are
law.
you saying that we should construe the term adequate notice as being broader than just compliance or lack of compliance with the court rules, that is a broader, more comprehensive term in terms of what adequate notice constitutes? Is that your argument?
Well, actually, Justice Kern, I would tell you that based upon what we've seen today, and this is not the first time that the appellant counsel and I have been together. This is our third year now doing this. Last year we were doing it with 4,000 signatures. This year 10. What I would respectfully suggest to the court, maybe to the legislatures, to come up with some way to adequately provide, because if you take appellant's argument to its logical conclusion, pursuant to statute, that would mean at the end of this coming month, as we are well aware, I see my time is running short, final point, is that if this, we're going to have independent nominating petitions filed at the end of this month. There are mayoral candidates running who will most likely file 100,000 signatures.
You didn't answer the question I asked, though, which is how we construe the term adequate notice. That was my question. I understand you're talking about the flaws with the system, but that doesn't really answer the question I was asking you.
I'm sorry, Justice. Well, I would say that we need to come up with some kind of rule, because I think that 15 signatures at issue is fine.
Are you arguing that on the current rule that he wins, then? If you're
No,
saying
I'm not.
You're arguing we have to come up with a new rule. You're conceding then that he wins under,
No.
I'm asking you how you win under the current rule that exists, in the current case law that exists. You're saying that we have to come up with a better system, sort of is suggesting that you don't think you win.
No, what I'm suggesting, Justice Kern, is that we win here because the volume, as Justice Perlman so eloquently pointed out, it's just so voluminous relative to what we've seen. as a case law.
Is your argument that there wasn't adequate notice based on the voluminous nature, and it's not just a simplistic matter of looking at court rules and the time it was received, but what was received in terms of whether it's adequate or not? Is that the argument you're making?
That is the argument, Justice Kern, because there was no way that we could have. And how could we have discovered this? We would have made the argument and we would have been done. It would have been facially tossed, as they say euphemistically, at the lower court level. They could not survive the Board of Elections. But because of the late notice, because it was 16 hours after the first appearance, because we had not been served with the underlying specs, we could not even get to them.
Just to pick up on what my colleague mentioned, the court, mindful of the fact that they comply with its rules to file it on the 22nd at 2 in the morning or 23rd, recognize, and that's what counsel's saying, recognize that notwithstanding this is my rules, we have a real due process issue here between 2 and 10 in the morning, correct? The court spelled it out in its decision.
Yes.
So the court was mindful of that.
I mean, the court, I don't think the court, when it set its part rules, anticipated that 10,000 de novo specs should be served at 2 in the morning, and it would be the very first time that anyone would see either the underlying specs or the de novos, because the specs were never delivered. That also is the
Well,
case
they
here.
gave the wrong ones.
The wrong ones, but they were never served. That's like saying you began an antitrust case, but you serve somebody with a motor vehicle case. It doesn't necessarily initiate the antitrust case.
So, counsel, I have one more question. In Justice Perlman's decision, he says that petitioners didn't take any steps to cure the issue, that is, the notice issue, cure the issue upon being notified of the service problem at counsel's first appearance on April 18th, 2025. So when he's talking about the service problem, he's obviously not talking about the service on April 22nd, because he said petitioners were notified of it on April 18th. So is that the service problem with regard to being served the purpose?
Actually, Justice Gessmer, I think that was a typo by Justice Perlman. If we first appeared in front of Judge Perlman on the 21st, is when we.
But still, it couldn't.
Says the 18th.
Even if it was 21st, it still couldn't have been the service on 22nd that he was referring to. So which service is he talking about as defective?
I think what he's talking about is that the service was made of the de novos at 2 in the morning after our initial appearance, which was
Well,
on
no,
Monday.
but he's saying that petitioners did not take any steps to cure the issue upon being noticed of the service problem at counsel's first appearance. But if you're saying the first appearance was April 21,
Yes.
then it couldn't have been notified of the problem at that appearance because it hadn't April 22nd hadn't happened yet.
Well, actually, Justice, I raised the issue. In fact, counsel and I had a colloquy with Judge Perlman at the time, and counsel had suggested to me, "Are you saying that his aggrieved candidate can never file?" And my report to counsel at the time was, "I'm not saying that. What I'm saying is that the service is inadequate, and therefore we are being deprived of due process. You can bring it, but when are you going to bring it? October? I mean, when are we going to get these things? That's our
very much.
point."
Thank you. You have a minute for rebuttal. I said you had rebuttal, but you don't because you.
Thank you, Your Honor. Very briefly, I mean, the service facial deficiency argument that counsel is making relates to two different specifications altogether. He's comparing paginated, automatically paginated specs that were filed as an aggrieved candidate with the manually paginated specs that were filed at the board. So this is what I've been dealing with since the conflation of the citizen objector and the aggrieved candidate proceeding. Counsel just said that there were issues, and Your Honor's question regarding Justice Perlman's issue, that the service was deficient, you didn't do anything, could only relate to the objector. The service of the specifications of objections at the board pursuant to the citizen objector petitions. It had nothing to do with the aggrieved candidate proceedings. And I responded to the court by saying, this is an aggrieved candidate proceeding also. So and at the argument on the 21st, I said, the specifications for this aggrieved candidate proceeding are due by 10 o'clock tomorrow morning, Judge. So I don't, I don't think there's any basis for the dismissal of this proceeding, and I know that it might be difficult timing-wise, but I think the precedent that this would set would render all practitioners and aggrieved candidates in disarray as to how they should proceed, or whether aggrieved candidates petitions even exist anymore, or do they only exist for local races where there are very few petitions, not countywide, not citywide, not statewide.
Thank you.
Thank you, Your Honor. Thank you. You do the same.